Dear students, let us start the discussion on today's newspaper, that is the 2nd November 2016. The first article, it is related to the misuse of the power by the center to, to circumscribe the constitutional provisions and to get the land acquisition bill passed through the states. So now let us see what are the constitutional provisions with regard to the concurrent list. The land management is a subject in the concurrent list. So, in these circumstances, the center has passed during the UPA government, the parliament has passed right to fair compensation, transparency in land acquisition, rehabilitation, and resettlement Act 2013. Later, it was realized that it is a big impediment with regard to land acquisition process for industrial development in the country. And World Bank from time to time stated difficulty in land acquisition and multiple laws governing the land and management of land in India is a major hurdle for India to achieve high on ease of doing business index. Even the Singapore Prime Minister, when he visited India, he has specifically spoken about the land acquisition laws in the country. So the 2013 law clearly states that there has to be social impact assessment, approval of the people before a land is acquired, and there has to be a clear rehabilitation and resettlement plan. Now, when it was about to be diluted, lack of sufficient majority in the Rajya Sabha is the major issue. So, in this case, what is the way the center is approaching now? Now, it is asking the state governments to pass their own laws on the land acquisition, and the center gets the president assent to the same. Now, how is it constitutionally valid is the question over here. Let us see it this way. Article 254, subclause 1, it states that whenever a law made by the center and a law made by the states come in conflict on a subject in the concurrent list, the central law will prevail. So, this is what is called as our doctrine of occupied field. But there is an exception under Article 254, subclause 2. If a bill of the state reserved by the governor for the consideration of the center and the President of India gives assent to that bill and it becomes an act with the President's due consideration and his assent, then the state law will prevail over the center's law. So, this is what the central government is depending upon. If a state passes the law, it will be reserved by the governor for the consideration of the president, and president will give the assent, and obviously it is going to override the parliamentary law. Now, the author criticizes it as violation of the spirit of the constitution. This Article 254 subclause 2 is given as an exception to the doctrine of occupied field is to serve the peculiar situation in the states, unique situations in the states. Its objective is not to undermine the authority of the parliament. Now, so the very provision 254 subclause 2 is being used to undermine the provisions and authority of the parliament. And the second criticism over here is the Supreme Court of India has clearly stated that in Kesari Hind and National Textile Company, it has clearly stated that any signature or assent by the President of India under Article 254 subclause 2 shall be with due application of mind, and it is also subjected to judicial review, as it is not the legislative power of the President but it is a legislative procedure. So, the author recommends that the President has to give due consideration in giving assents to this bill. If not, it becomes a precedent. Wherever or whenever the government do not possess the majority in the Rajya Sabha, then obviously it will try to take this particular detour to get its will passed through the state legislatures. And the second thing is, what the government cannot do directly, it cannot do indirectly. It is also violative of the same dictum. So that's what is the argument over here. Next is questions about encounter. Now, 8 prisoners who have jailbreaked were encountered and they belong to the Simi. So, in this case, is this encounter is real or fake is the major question. Beyond that, let us see something which the Supreme Court has said about the police violence. The criminal act by a police to counter the criminality is not in accordance with the rule of law. Because the police as an establishment is a state apparatus and it has to believe in the rule of law. And if it is also resorting to the breakdown of the rule of law, then there is no difference between the criminals and the trigger friendly police. So, and as rule of law, the law has to apply equally for all, including the state, including to the police people, including to the criminals, including to the ordinary citizens. That is the dictum. So, in those circumstances, the police personnel will also be tried for murder, and even they can be given the capital punishment if it has been proven. And in the case of PUCL versus State of Maharashtra, that is People's Union for Civil Liberties versus State of Maharashtra, the Supreme Court has clearly stated certain guidelines in dealing with an encounter situation. And now, the state government of Madhya Pradesh has to follow these guidelines, and to uphold the rule of law, it has to ensure that proper investigation is done into the case. And if there are any culprits, or else if there is any wrongdoing, it need to be severely condemned for. Because the human rights are available to all the people. They do not differentiate between ordinary citizens and criminals, etc. And the schools out in Kashmir. Now see, an education is an enabler. It is necessary right of a child. So, curtailing the education to the future generations cannot be a base or a basis for any movement. So, in this context, recent burning down of the schools in Kashmir is a misnomer. So, it has been suggested that all the sections of the Kashmiri society has to condemn certain or such acts. But however, Kashmiri separatists not coming forward in this scenario is not a welcome step. So, at the same time, the government also shall not lodge its military and paramilitary forces in the schools, because lodging them in the schools makes them as the symbols of the state and vulnerable targets for these separatist and terror elements. So, providing for the education is the right of the child, and no one shall deny this right. Whatever the movement is, it shall not deny that right to the child. Now, let's go to the perspective articles. FBI on the mat. Now, I am from for me, this question is related to corruption and institutional independence. More than what is happening in the United States of America, what is supposed to be, or what is the lesson Indian institutions has to learn from this is more important. The first thing is neutrality is a guiding principle for any bureaucratic agency. So, based on this neutrality, the actions of an investigative agency or an institution shall not lead to shall not lead to influencing an election or a democratic process. Now, the FBI's very action on reopening the case of emails related to Miss Secretary of State Hillary Clinton is influencing the election process. And second thing is, independence of the institutions and security of tenure for its personnel is very critical for its independent functioning. So, in USA, FBI director, he has 10 years of tenure and he can only be removed by the Congress. It means even tomorrow Hillary gets elected, she cannot remove Mr. Comey, who was the FBI director, because the Senate has approved his appointment and can only be removed by the Congress, and it means that a security of tenure is provided to him. Now, let us take the situation of the CBI. It has 2 years of tenure, and then at the same time, there is no legislative sanction for his appointment, and his removal is in the hands of the executive of the day. So that's why the CBI in India is described as a caged parrot and is being misused for various political purposes, which is compromising on its neutrality. Next is why diversity needs a secularism. Now, I found a beautiful statement over here, that is, diversity is a political project, can only be effective with secularism as a working foundational value. So, now, When we talk about diversity, we are talking about religious diversity, institutional diversity, cultural diversity, etc. And unity has to be maintained amidst of this diversity. So this can only be possible with the project of secularism. Now, in this context, I want to give you the statement of Rajendra Sachar. He has clearly stated that there is a double tragedy for the Muslims. One way they are criticized as beneficiaries of the appeasement of the government, and the other way they are criticized as anti-nationals and also victims, and at the same time they are victims of the communal violence. So they have to prove their nationalism on a day-to-day basis. As Indian political environment is getting filled with the venom of communalism or venom of right wing politics. That's what I mean. Though he did not clearly say the right wing politics, he said, as the communal divisions are growing in the society, it's becoming more and more dangerous to the people to live in, especially the minorities. So, in that scenario, if you see this article from Janata government onwards, where the BJP or then BJP was also a part of it, or then the Janasangh was a part of it, there is slowly consolidation of the right wing politics in India. And then Advani's Radhayatra, and after that NDA 1, NDA 2, there is culmination of the right wing politics in Indian major political landscape. So here Hindutva has started dominating the political debate. So according to them, the secularism has done greater harm to Indian politics than good. And it also is not beneficial to the Muslims, that is the argument. And it is keeping the Muslims poor by making them just the beneficiaries of the government rather than making them empowered. And the second thing is, the argument put forward by the Home Minister Rajnath Singh is the original constitution did not include the secularism in preamble, and it was brought in during the 42nd Amendment Act, an emergency amendment which was brought in. So, in this, the Janata government has later corrected the mistakes of the 42nd Amendment Act through 44th Amendment Act, but however, they did not touch the word secularism in it. So it means that the Janata government also has fairly satisfied that secularism is necessary. And the second thing, our foundational fathers, they did not keep the secularism in the preamble because there are many provisions which explicitly state the secularism as part of this constitution and where the secularism is being protected. And when the debate has happened in the Constitution Assembly, Mr. Dr. B.R. Ambedkar has replied to K.T. Shah, and this reply is pertained to socialism, not to the secularism. What he said is the future generation shall not be deprived of their freedom to choose what the nature of economic association they want to have. So the statement is clearly related to the socialism, not to the secularism. So, the secularism also declared by the Supreme Court as part of the basic structure of the Constitution, and it is necessary for the peace, prosperity, and unity of this country. Now, coming to, with regard to the encounters, what are the various Supreme Court judgments? Instead of going through all these things, just remember PUCL versus State of Maharashtra. The Supreme Court has given clear guidelines with regard to investigation of an encounter case, which has to be by an independent agency. And then, lesser wages for equal work is violation of human dignity. Supreme Court has said that equal wages for equal work, it is in alignment with the principle of equality enshrined in the Constitution. And if any person is being paid less, it is equivalent to the exploitation of that particular individual in this judgment. Now, PMI. What do you mean by PMI? It refers to Purchasing Managers Index. What essentially it shows? What is the demand or domestic demand for the manufactured goods? That's what the Purchasing Managers Index shows. So according to this, if it is less than 50, the demand is contracting, and above 50, the demand is expanding. Now in India for 10 consecutive months, it is on a positive space of Purchasing Managers Index. It means the demand is expanding. So there is a good market in India for the manufacturing goods now. So this is what Purchasing Managers Index does. Now, I have expected a question in prelims last year and it did not come on Purchasing Managers Index. But however, every year UPSC is giving one or two questions related to indices. Global Hunger Index, Purchasing Managers Index, or something can come up this particular year again. So try to take a look on this. So thank you very much and all the best.